So good morning, everybody, or good afternoon, I guess I should say at this point. My name is Alicia Moran, and I'm the Manager of Small Business Development here at Prince George's County Economic Development Corporation. And I want to welcome you to the fourth of a series of programs that we've been doing with Lurch Early Brewer. And so today's topic is contracts. What new and small businesses need to know. And it's going to be an exciting topic. So next slide, please. So I just wanted to let you know that this again is a partnership with Lurch Early Brewer and Prince George's County Economic Development Corporation and Innovation Station. This session is being recorded and will be shared with others. So just please be aware that this session is being recorded and will be shared with others after this event. Next slide. And so throughout this series, we've covered everything from company formation to buying and selling a business, as well as managing employees. And today we're going to be talking a bit about contracts and what actually is a contract, what constitutes a contract, and what does that mean to you as a small business owner. We're also going to be addressing some issues around bankruptcy and elements that may be helpful for companies in that area as well. Next slide. So this is my point of contact. Most of you know me most likely. I am Manager for Small Business Development, as I mentioned earlier. And you can feel free to email me at any time. You know, I'm available day or night. We're all working COVID hours, and so we're all here to help you manage your way through this turbulent time. So just know you have a partner at PGC EDC, Prince George's County Economic Development Corporation, and a whole team of people behind you to support you in your business efforts. Next slide. Some of the services we provide obviously are training and workshops like this, as well as connections to financing. We work closely with FS First, our financing partner in the county. We work with site selection, we assist with permitting, we assist with working with our partners, whether that's SCORE or Small Business Development Center, the Procurement Technical Assistance Center, TEDCO, the Minority Business Development Agency, etc. Next slide, please. And this is just, again, a list of all of our resource partners and places and people we may connect you to, depending upon what your needs are. Next slide. We also manage Innovation Station, which is a business incubator and collaborative co-working space. You kind of see that behind me. In normal times, we would have these sessions maybe in person at 1801 McCormick Drive. It's all about fostering job creation, business retention, business expansion. We're offering turnkey solutions, whether that's office or co-working space, peer-to-peer learning opportunities. We provide grant opportunities to our business incubator companies and access to a host of business development support services. Next slide. And today, we're really excited because we are here to talk about contracts and contract law. And so I'm pleased to present our presenters, Sharon Craig, Robert Gordon, and Vernon, whose last name is being cut off. So I'm going to let Sharon introduce you all to everybody here, and just know that you're in good hands and we have great expertise, and we're really pleased to have this partnership with Lurch Early Brewer. It's been a fabulous journey thus far, and we really look forward to an engaging session. Thank you so much, Sharon. Off to you.
Thank you, Alicia. Good afternoon, everyone. It's our pleasure to be with you today to talk about contracts. Just a little bit about ourselves. Vernon and I are commercial real estate transactions attorneys representing property owners, developers, investors, landlords, and tenants in sophisticated commercial real estate transactions. Robert is a bankruptcy and creditors' rights attorney who focuses on representing clients in DC, Maryland, and Virginia. Prior to joining Lurch Early, Robert served for 14 years as a judge on the U.S. Bankruptcy Court for the District of Maryland. The special thing about the three of us is that we have all been friends for about over 30 years. We all worked together prior to joining Lurch Early, and it's exciting for us now to be able to practice together in our more seasoned years and make this presentation to you today. We all speak from experience in representing small to medium to large businesses and institutions, primarily in commercial real estate. We've prepared and negotiated many different types of contracts for our clients and even for ourselves. In fact, while Robert was on his path to become a bankruptcy judge, Vernon and I had our own law firm back in the late 90s. So we were in your shoes, forming, operating, and running our own small business law firm. And it was just the two of us. So as you can imagine, we wore many hats. We were the lawyers, we were the marketers, we were the bookkeepers, we were the IT department when the computer system didn't work, we were the maintenance person when the copy machine jammed, we were the office clerk, typist, all that comes with starting your own business. And with any small business, Vernon and I, through our limited liability company entity, had to enter into many contracts in starting our business. We entered into a lease agreement to rent office space in downtown Baltimore. We entered into an agreement to rent office equipment like copy machines. We entered into an engagement agreement with an accountant to help us keep our books and records and to pay Uncle Sam our taxes. We applied to a bank for a line of credit, and we entered into a promissory note and a security agreement. We also responded to requests for proposals like RFPs for legal services from government agencies like the Maryland State Pension System and the Maryland Department of Transportation. And we entered into joint venture agreements and teaming agreements with larger law firms to get that business and to be able to provide those services. And when business was booming and Vernon and I could no longer wear all of the hats, we hired an associate attorney and entered into an employment agreement with her. All of these agreements that Vernon and I entered into through our LLC are contracts. So the question is, what is a contract? What are the legal requirements for a valid contract? The elements of a valid contract are offer, acceptance, meeting of the minds, consideration, capacity, and legality. Let me make sure that Scott has caught up with me on the slides. So Scott, you might want to move on to the next couple of slides. Yep, I covered that one. So now we're on the one for that. Yep. So first, there must be an offer. So when Vernon and I leased our office space in downtown Baltimore, the landlord's broker presented us with a letter of intent with the basic terms of the deal. And Vernon's going to talk more in detail about letters of intent a little bit later. We eventually agreed upon the terms. And from that document, the landlord had its counsel prepare a lease agreement for a 5-year term with renewal options at a rent that Vernon and I had to get comfortable with that we could actually pay. So the offer to us was the lease agreement. The acceptance was the document that we ultimately executed with the landlord. The meeting of the minds was that both the landlord and me and Vernon intended to be legally bound by the document. So the landlord would lease us the space, we would occupy the premises, and in exchange, we would pay the landlord the consideration, or as more commonly known as the rent. The lease was for a legal purpose. So for example, the leasing of office space is a legal action as opposed to an illegal purpose like agreeing to enter into an agreement to rob a bank. Obviously, robbing a bank is an illegal action, so the legality of it would be in question. And both Vernon and I were way over the age of 18, so we weren't minors at the time who did not have the capacity to enter into a binding agreement. And we were mentally competent, and so was our landlord on the other side. So in other words, we had the capacity to actually enter into the lease agreement. Our lease agreement was in writing. So written contracts are required in certain types of transactions, such as real estate matters and debt repayment agreements. Oral contracts are actually generally enforceable in Maryland, but if there's a contract dispute, a judge would have the 4 corners of the document in addition to the facts and circumstances and evidence to resolve the dispute. In an oral contract, you're pretty much relying on one party's word against the other. So I would ask that no matter the relationship between the parties, I don't care if it's your sister, your brother, whomever, having an agreement in writing always protects both sides. So those are the elements of a contract. And so before I turn over the next part of the program, I want to at least mention a few standard provisions in what I've seen in all contracts, whether they're real estate related or not. Question, who are the parties to the contract? I recommend that you create an entity or multiple entities for your business. When you sign a contract in an individual basis, it could have the effect of exposing the assets that you own, such as a home, to attachment in the event of a winning claim by the other party. And also make sure you investigate the other party to the contract. In the example of the lease that Vernon and I executed, we checked to make sure that the landlord on that lease actually owned the property that they were leasing to us. We also got a document from the landlord that verified that the party executing the lease on behalf of the landlord actually had the authority to sign the document. Confidentiality and intellectual property. If you're entering into a contract where information about your trade secrets or methods of operating your business or production of goods could potentially be shared with the other party, you should include confidentiality provisions and intellectual property protection provisions in your contract. Now, I can't say that this is our specialty on this team of lawyers per se, but other lawyers at Lurch Early have experience with these clauses. I mentioned these clauses particularly today simply because of the importance of those clauses and provisions in protecting you and the business that you have created. Those provisions can be very long and detailed, but the purpose of them primarily is to make sure that they protect any of your trade secrets or methods of operating your business or how you do your business. Confidentiality is important from the standpoint of there may be certain areas or provisions that don't need to be shared with the public. Now, if they're public already, then there's no need for a confidentiality clause. So there are exceptions to the confidentiality requirement. But I suggest that you definitely include those types of provisions in your document. The third type of clause I'd like to talk about, and let me make sure my slides are, thank you, Scott, is indemnification. I would bet money on any online contract you look at that I hope you're not using, or that a lawyer drafts for you. It will contain the word indemnify. So what does the word indemnify mean? How do indemnification and insurance clauses relate? Technically, indemnify means to compensate for harm or loss. So if a party to a contract fails to perform, or if something happens to a third party as a result of a party to the contract's actions or inactions, that party might be required in the contract to indemnify the other for any losses, claims, and damages suffered by that party as a result. As an example, in the commercial real estate world, tenants and buyers perform due diligence on the real estate before they either lease or buy the property. And that due diligence is typically done by an expert third party, such as a surveyor, an engineer, an environmental company that the tenant or the buyer hires to do that for them. The landlord or the seller will probably require that the tenant and the buyer indemnify them for anything that happens on that property during that due diligence period. So for example, if an environmental company is out there on the property doing borings into the ground to see if there are any hazardous materials out there, and that company negligently hits a water line, the landlord or the seller is really going to hold the tenant buyer responsible and require that tenant buyer to indemnify them for any cost or liability that it might suffer as a result of the environmental company's work on the property. So as you can imagine, the cost to indemnify could be extremely significant. So most companies use insurance to secure indemnification obligations. So that's how indemnification and insurance are related. These clauses and contracts can run for 3 pages, and they can expose parties to a significant amount of liability. So, but they're important and they need to be paid attention to by you and your lawyer. The next category of provisions I want to talk about is force majeure. And this concept has come up particularly during COVID. A force majeure provision provides for an excused delay in the performance by a party for reasons beyond their control. Strikes and acts of God were typical force majeure events, like weather events, that could give a party some extra time to perform if any of those things happened. Usually the documents provide that force majeure clauses are not applicable, though, to the payment of money, thereby meaning that no matter what, the paying party still has to pay. COVID and government shutdowns as a result were not expressly in a lot of standard contract language before this all happened. So when this past year occurred and tenants could not access their premises due to occupancy restrictions, or they could not pay their rent because their businesses had to close, many of the tenants attempted to assert force majeure clauses so that they would not be deemed to be in default under their leases. And most landlords rejected those claims. Vernon and Robert and myself will talk more about this a little bit later in the program, because a lot of it depended on the four corners of what that force majeure provision in the contract stated. And now what you see now in new contracts and agreements that are being entered into now, particularly leases and purchase and sale agreements, you will see beefed up force majeure clauses that actually mention COVID and variants of the COVID virus. So that's something that's kind of a new development with respect to force majeure clauses. Next, I'd like to talk about default clauses. So breach of contract provisions are usually specified in the contract. And the more reasonable ones of those provisions will at least allow for a notice and cure period to happen, before the alleged breach actually rises to a level of default. So if you haven't paid your rent and you get a, you get a notice that says, if you don't pay your rent within 5 days of this written notice, you'll be in default. That 5-day period is your cure period. The remedies of either party in the contract can include, depending on the type of contract, the right to terminate the contract, the right to bring suit, the right to damages. Sometimes you'll have alternative dispute resolutions as opposed to going to court, like arbitration or mediation as another way of remedying the issue. And the purposes of these clauses, particularly the damages clause, is to try to restore that party's position, to restore that party's business to the same position it was in before the other party breached the contract. Specific performance is another remedy where damages may not be adequate to make the claiming party whole. So there are different types of remedies, there are different types of default provisions, but it's best for the parties, kind of going back to the meeting of the minds, to know what's going to be the consequences if one of them defaults. It's best to have a meeting of the minds on those provisions. The other thing I want to mention about default clauses is that one provision that should be included in a Maryland contract is a prevailing party provision, which generally provides that if there is a lawsuit, the unsuccessful party is required to pay the legal fees and cost of the successful party. You have to include this provision expressly in a contract if you're going to be the party that's going to benefit from it. So I just want to mention that, as that's something that some people don't think about when they do particular contracts. So those are some standard types of provisions that I think kind of run the gambit of across all types of contracts. Usually you will see some provisions relating to each of those 5 items in a contract. Lastly, I want to talk about contract administration. Once you sign the contract, now what? Do me a favor and don't file it and forget about it. I see a lot of clients who spend a lot of time and money negotiating and entering into agreements, and then don't put in place any way of monitoring the critical dates or the deadlines in that contract. And you can't rely on the other party or your lawyer to do that for you. An example of this is a lease renewal. In the lease that Vernon and I signed for our office space in Baltimore, we had a lease renewal option beyond our 5-year term. We were required by that lease to notify the landlord in writing 6 to 9 months before the lease expired if we wanted to renew the term. If we failed to send them that notice, we lost the right to renew, and we would have had to vacate that space by the end of the 5-year term. Missing these types of dates unintentionally can have extremely disruptive effects to your business. So I strongly suggest that after you sign a contract, no matter what type it is, that you create kind of a schedule of critical dates, and that you put these dates in your calendar and maybe the calendar of your assistant, and you set it up so that reminders come up in advance of the actual deadline for the date, so that you're aware to make sure that you don't miss something critical in one of the contracts that you just spent a whole lot of time negotiating with the third party. So that's part of my presentation. Thank you very much. Now, Vernon is going to talk about a specific type of contract that I've alluded to, a real estate lease. Thank you.
Nice job. Thank you. Mr. Lynch, I think we're turning it over to you now, sir.
Okay, can you hear me?
Yes.
I think I was on mute. Okay, great. Good afternoon to everyone. I saw some questions scroll across the bottom, but I don't know if they were specific to Sharon's presentation or not. So if not, we can perhaps address some of those at the end of the presentation. With respect to a lease, the starting point is typically going to be a letter of intent. And Scott, if you could go back to the immediately previously, yes, slide, yes. The starting point is usually going to be a letter of intent. And the letter of intent most often is going to be prepared by the landlord or by the broker for the landlord, and is going to set out certain, what I would refer to as basic terms that are to be reflected in the lease. The letter of intent will identify who the landlord is. It will identify who the tenant is, and it will oftentimes also indicate that the landlord is going to require or may require a personal guarantor of the tenant's responsibilities under the lease. Scott, would you go to the next slide, please? So the letter of intent in setting forth the principal basic agreements to be entered into by the parties will also specify what the premises are that are going to be leased by the landlord to the tenant. It is very important that those premises be specifically defined because you want to make sure, as the tenant in particular, that what you think you are going to be leasing is in fact what you're going to be leasing. The other thing that you want to be sure is what is the condition of the premises that you're going to be leasing. Oftentimes, the letter of intent will not address what those conditions are, what that condition is, but it should. Landlords will oftentimes include in the letter of intent that the premises are being leased in their as-is condition. And what that means is whatever condition those premises are in, that the landlord is saying to the tenant, you agree to accept this physical condition of the premises. I, as the landlord, I don't have any responsibility to make any improvements to this space to the extent the space might be in disrepair. The landlord may be saying that it doesn't have any responsibility to make repairs to those premises prior to delivering possession of those premises, to the tenant. To the extent it's a situation where the landlord is agreeing to perform certain work to the premises prior to delivery to the tenant, that should be spelled out in the letter of intent. And to the extent the tenant either needs to perform certain work to the premises in order for it to satisfy the tenant's needs for operation, or to the extent the landlord requires the tenant to perform certain work, then that should be reflected in the letter of intent as well. Another item that is typically addressed in the letter of intent is the term. It certainly will address the initial term, and it also should address if there are any renewal options. And to the extent there are any renewal options, then the letter of intent ideally should specify what are the conditions for the tenant's right to exercise that renewal option. As Sharon had indicated in her presentation, in almost all leases, there is a requirement that the tenant give the landlord prior notice, and that can range anywhere from 6 months to even a year before the expiration of the then current term of the lease, that the tenant intends to exercise the renewal option beyond the then current term. And to the extent the tenant misses giving that notice to the landlord, it could mean that at the end of that term, that the tenant has to vacate the premises. But the other thing it could mean is that the landlord can say to the tenant, yes, I will allow you to continue to occupy these premises, but I now want to change the economic terms under which you can occupy the premises beyond the current term. That could mean an increase in the rental rate. So it's very important to understand what the conditions to exercising the renewal option. Another condition that oftentimes is imposed by the landlord, especially where the lease is for a retail operation, is that at the time of the exercise, the tenant actually has to be operating its business in the premises. The landlords typically don't want a tenant exercising a renewal option, if the tenant has gone dark, which means it's not operating, in the premises, even if it's, temporary, while the tenant perhaps, reorganizes its business or what have you. So it's important to know what those conditions are. Obviously, the letter of intent is going to address the rent. The rent is typically going to be specified as a certain dollar amount per square foot of space within the leased premises. It is very important that the tenant understand what that translates into in terms of what its economic liability is for payments of rent, not only monthly, but annually. It is also very important that the tenant understand, to the extent the letter of intent provides for annual escalations in the rent. Most letters of intent, like most leases, have provisions to say that the rent is going to increase periodically. Typically, those increases are annual increases. There are some instances where the increases occur at the beginning of option periods, but most often those increases are annual escalations of the rent. Typically, they're going to be, stated as a certain, percentage increase. So by way of example, that the rent will increase 3% a year. And we're talking about the base rent, will increase 3% a year. So it's very important for the tenant in evaluating whether entering into this lease makes economic sense for it to schedule out those rent increases over the initial term of the lease and even the renewal periods, but especially with respect to the initial term of the lease, to understand what its financial obligation is going to be to the landlord. Another component of the rent that oftentimes tenants, especially new businesses, don't quite focus on is what are referred to as pass-through obligations. So to the extent the lease premises are, and let's take the example of either being in an industrial park or being in a retail shopping center, then the landlord is going to pass through various common area costs to the various tenants in the center or the park. And those common area expenses will be for maintaining of the parking lot. It will be for, maintaining the exterior of, building, structures. It would be for, it could be for, to the extent, the landlord has to pay, it's part of a condominium regime, has to pay, some type of condominium assessment, then the common area expenses that get passed through the tenants might include a tenant's proportionate share, of those costs. Other pass-through costs are real estate taxes and insurance. And typically, the portion of those common area expenses, real estate taxes, and insurance that the tenant is responsible for is going to be the size of its premises, the percentage that its premises bears to the total leased premises in the shopping center or the office building or the park. So that could end up being 5% or 10% or 3%, but whatever percentage it is, it's very important for the tenant to understand what that percentage is, to ask the landlord to provide the tenant, and this is at the point of the letter of intent, the past history for those costs at the center or at the park or the building, so that the tenant can do kind of a projection out of what those costs are going to be to the tenant, because those costs are going to get added to the rent, and they're going to be costs that the tenant is going to pay in monthly installments along with the rent. So when you think of rent, you have to think beyond just the base rent. You have to think about these various pass-through costs, because those are financial obligations that the tenant is going to have to the landlord as well. The letter of intent is most likely for a new business, is going to require that there be a personal guarantee of the tenant's obligations under the lease. And as Sharon had indicated, ideally, what any new business should do is to set up either a limited liability company, or a corporation, that that's its operating vehicle. I highly recommend against, any individual signing a lease in his or her individual capacity. But even where you form a business entity, such as a limited liability company or a corporation, if it's a new business, then the landlord is likely to require that there be a personal guarantor, and that personal guarantor is most often going to be you, the owner, of the business. And there's, very little likelihood that you're going to be able to avoid providing a personal guarantee. However, there are opportunities to limit the liability that you as an individual might have under that personal guarantee. That personal guarantee is going to be a separate contract document between the landlord and the guarantor. So I would say, because I really believe that an attorney should be engaged, for all of these phases, the letter of intent, and most certainly the lease. But an experienced attorney can help a tenant attempt to negotiate limitations for personal liability under the personal guarantee of the tenant's obligations, under the lease. Once you have the the letter of intent, executed, the landlord is going to provide a lease document to the tenant. And I believe it's extremely important for the tenant to read and understand all of the provisions, of that lease, because again, it's a binding document, which, the tenant will be expected to, comply with. I highly recommend that the tenant engage legal counsel to represent it in the review and negotiation of that lease. I know that lawyers are expensive. However, a tenant can discuss with the attorney ways to limit the amount of the legal fees. There can be a limited review of the lease document as one way of limiting those legal fees. But most assuredly, an attorney reviewing that lease is going to end up saving that tenant much more in terms of actual cost or potential liability than the legal fees that the tenant pays to the attorney. With respect to the lease, again, it's important to know about the premises, that they are specifically defined, as well as the condition. With respect to the commencement of rent, that's an important item that's going to be reflected, in the lease, and oftentimes it is reflected in the letter of intent. Some leases provide that the obligation to pay rent commences immediately upon execution of the lease. Other leases provide that the rent obligation commences when the landlord delivers the lease premises to the tenant. And to the extent the landlord has to perform, work prior to delivery, then that work has to be complete. Other leases where the tenant has to perform work, then what the tenant should try to negotiate in the letter of intent is that the tenant has a certain period of time after the landlord delivers possession to the tenant for the tenant to perform its build-out work or to install any fixtures that it needs in terms of its operation before the commencement of rent occurs. Depending on the amount of work that has to be done, depending on the type of lease, that free rent fixturing period can be anywhere from 30, 60, or 90 days. The other thing that where the tenant wants to be sure that if the nature of its business is one that calls for a specific permit to operate, or if the nature of the tenant's improvements that it has to make to its premises in order to operate its business, that the tenant should attempt to negotiate a permit contingency in the lease, so that if, despite the tenant's due diligence in applying for that permit and pursuing that permit, the tenant does not receive that permit, that the tenant then has the option to elect to terminate the lease. In the absence of having a permit contingency where one is really needed, if the tenant is not able to secure that permit from governmental authorities, then the tenant will nevertheless continue to be liable for all of its obligations, including the rent, under the lease, even though the tenant is not operating the premises and therefore is not generating revenue from the premises in order to be able to, to satisfy those rental obligations. Just a couple of other things, and I want to make sure I'm not running terribly over on time. A critical item to review in the lease is the assignment and subletting provisions. There's a lot of optimism when any business gets started. that's just the nature of being an entrepreneur, you know, that I'm going to start this business. It's going to be very successful. It's going to grow, etc. Well, for that reason, you need to look at the assignment and subletting provisions, you know, in the lease, because let's say that you are successful in growing your business to the point where you want to sell that business. Well, if you don't have an assignment provision that allows you to sign the lease in connection with the sale of your business, then to the extent that business really needs to operate from that location, you're not going to be able to move forward with the sale of your business. Most leases contain a provision that prohibits the assignment of the lease by the tenant without the landlord's consent. Most leases typically are going to say that that consent is in the landlord's sole discretion, in which case that's a really big hurdle for the tenant to overcome. Some leases provide that the landlord's discretion has to be reasonable, but even in that situation, there are some hurdles that you know, that the tenant might, you know, find difficult to overcome. So it's important to not only review that assignment provision, but to fully understand it and to negotiate some flexibility in that provision. The other reason why the assignment provision is critically important is because let's say that your business does not go well, you know, that it's not performing the way that you had projected, you know, and you really need to get out of the financial responsibilities under the lease. Well, the landlord is not going to just let you terminate the lease, you know, and walk away. The landlord expects that you're going to honor, you know, your obligations under the lease, excuse me, and continue to pay rent. Well, if you have an assignment provision that is flexible, then you might be able to assign the lease to another, you know, business person or another business, in which case they become primarily responsible for performing the tenant's obligations under the lease, including paying the rent. Now, the landlord will not fully release you from your responsibility. So if that assignee tenant does not perform, then the landlord may still look to you. However, you know, to the extent you're able to assign the lease to another business, then presumably that business is going to have the primary responsibility for, you know, occupying the premises and paying the rent. That is one way to get some relief financially and economically if in the event your business projections and plans do not turn out the way that you project. And I think that's pretty close to the end of my time. So at this point, I will turn it over to Robert Gordon to talk about bankruptcy and insolvency.
I think, Robert, before we start, there were a few questions that came in that I think I can address. I'm just going to read them briefly and then respond. One attendee said that she's responding to an RFP that was released by a major retailer. They have standard payment terms listed in the RFP, 60 days after acceptance, which is a mismatch for her business. Her payment terms are 50% deposit, 50% upon delivery. And the question is whether or not she should note that in the response to the RFP, or does she just acquiesce in the terms of the proposal? I think what I've done with RFPs in particular on situations like that is I would provide your payment terms as an alternative, but make it clear that, you know, you would not want to be eliminated from the competition as a result of this. You would like to discuss it further or something to that effect, to show that you're willing to address the issue, but you need to probably explain in that your response why your payment terms are what they are. And maybe, you know, so in other words, don't eliminate the opportunity to say what your terms are versus what the RFP actually requires in that instance. Just going down the list, what type of law or specialty should a general services business retain? I would suggest a business lawyer. If that could be your starting point. If that lawyer doesn't have other expertise in like real estate or employment or some other litigation, at least that person can help you from a general business standpoint to get your business going, and may provide you with referrals for real estate or other types of areas of law that you need. But a general business, corporate business attorney should be able to address most of your issues, and then you can certainly take advantage of the referrals that he or she may make for you. One other question, and this came up a couple of times. We have a lot of contracts, particularly NDAs for various clients that all have specific dates, milestones, and deadlines, and staying on top of them has been a challenge. Beyond using calendar notifications, are there services or software applications that you recommend that help track these dates and provide notifications for them? Someone else asked a similar question, which was, is there a software tool to help people keep on top of contract elements? I'm not aware of any specific software, because the bottom line is this: even if you have software, it's only as good as the data that's put in it. So unfortunately, you might want to designate somebody in your office or hiring somebody from the outside that's kind of your compliance person, who has the capabilities of going through those contracts, knowing and seeing what those dates potentially could be, and inputting them into your system. Like I said, I'm not aware of any particular software, because a lot of it just depends on the data that's inputted. So once the data is inputted, even Microsoft Outlook will work to notify you and reflect it in advance. But unfortunately, some of that is going to have to be manual labor. Lastly, I think the other question, let me see, did I miss one? I thought there was another one about a partial payment. Hold on. Someone had unwritten verbal agreement and got a partial payment for services, but the person disappeared. Now they're back and want to complete the project, but it's got new parameters. How can they address? Can they provide a refund if they don't want to work with them again? Or do the funds already paid need to go to the current project? I think it probably depends on what type of project it is. If it's just a project that you hired the person and you made them a payment and then they didn't finish the job, I don't think you have, if it's oral contract, it's not a written agreement, depends on the facts and circumstances in terms of what led to the person disappearing in the first place. But my general reaction to this question would be, you probably don't have any obligation to continue with them unless they're alleging something. A lot of times you can learn about where a situation is going to go just by what that person alleges. Communication in this regard, I think, would be important to find out what's the purpose of this person coming back at this stage of the game. I'm not sure how long a period of time it was between the partial payment and the disappearance, but I would kind of measure this by, what type of reactions and interaction and communication you have with this person before you make a decision. I think that was all of them that are I think that's it. So Rob, I think you're up.
Sure. Hi, folks. How are you? First, let me just say it's a real honor and a pleasure to be here as a part of the partnership. Education is key. So you're already taking a huge step by being here, participating, listening, taking notes, whatever you're doing to absorb the information and make sure that it's something that you can rely on in the future. But the other side of the equation is to act on it, to be effective in making sure that you take heed from the good information that we're trying to share here. And I'll just say that I just have to say this, my 96-year-old mother got her second COVID shot this weekend. So I'm very happy about that. And I hope everybody out there is COVID-free and getting a shot if you are eligible for it. Sharon said we were all seasoned. That's a great way of putting it. I think Sharon's a wonderful, eloquent lawyer, especially for that. But I'm not quite seasoned enough to be eligible yet. So here we are Zooming together as life on life's terms has it for all of us. At this point. So you might ask the question, I thought this was about success. I thought this was about realizing my dreams economically, business-wise, et cetera. So why do you have a bankruptcy lawyer here? Why do you have a former bankruptcy judge here? Well, I think I've probably learned as much as anyone how things can take a wrong turn and how things can go south. And when that happens, what to do. But let's talk a little bit first about what to do to try and make sure that doesn't happen in a sort of general way, because I think these points are very important, especially and valuable, especially for those who are, you know, in the early stages of their business. And for me, I've been doing this almost 40 years. So I've gained 40 years of depth and experience in this work on every possible side of the equation. I've been a pitcher, a batter, and I've also been an umpire for the past 14 years. And now I'm back in private practice and happy to be here with Lurch Early for just 6 months now. So, but the point I'm making is I think I can offer a unique perspective that probably cannot be matched in this region. And I don't say that out of ego or anything else. There are former judges who are doing the same thing I'm doing in other parts of the nation, but having that perspective, having a knowledge, a well-grounded ability to sort of predict what might happen in a given situation, I think is just a valuable asset that, you know, is there to benefit the client. And I'll say this also, you have our contact information on the slides. I'm sure that the Economic Development Court would be happy to share them with you. If you don't have them on the slide, feel free, and I mean this, feel free to call me up, send me an email, etc. You're getting a lot of general information as an attorney and especially as a judge. I always wanted to know the details to be able to give a cogent, trusted opinion on whatever the topic might be. So, guarding against insolvency, let's start with that. And I'll just say right up front, sometimes the financial circumstances, the context, make that almost impossible. You see on one of the slides, we had the example of the craft maker who decides to move out of the home, I believe it was, and into a location where her business would be the tenant under a lease. Well, keeping it simple, suppose, for example, a new business opens across the street from our hypothetical craft maker, a type of business that's off-putting to her customers, a bar, a motorcycle repair establishment, etc., or even a competitor that just has a slightly better location that impacts on our hypothetical tenant's business. Suppose she starts to lose money at that point and is stuck in that location with 3 more years on her lease term. I know that phrase was mentioned. You enter into a lease. I think generally 5 years would be, you know, an average amount of time considered reasonable for a landlord tenant. You're there with a 3-year lease and, you know, it appears there's nothing you can do about it. In that instance, bankruptcy might be a legitimate option for reasons that have nothing to do with that individual's ability to run the business or a failure to do the things that they should have done to keep themselves financially sound. In other words, circumstances beyond their control. What has the Supreme Court said about it? Let me just read you this quote, because I think this is something that, as we say, it's oft quoted in bankruptcy, and I think it rounds out the entire system in just perfect language. Supreme Court wrote in 1934, bankruptcy gives to the honest but unfortunate debtor a new opportunity in life and a clear field for future effort, unhampered by the pressure and discouragement of pre-existing debt. Couldn't say it better. Words said a long time ago, but they still absolutely apply today. But To avoid that option, because no one wants to do it, correct? We can, I think, all agree on that. How do you avoid it? Know and understand your legal and business obligations. The truth can sometimes be painful, but it must be accepted. And gaining the knowledge of the terms of your lease, gaining the knowledge of the contracts that you're bound to, will give you that knowledge. I know you want to focus on making money. You want to focus on your business plan. You want to focus on being successful in that way, but you don't want to miss anything that's important. So how do you do that? Many of those obligations you will know and understand on your own. But in order to really be ahead of the game, you need competent, qualified professionals to advise you as to the meaning and effect of them and how they'll impact on your business and financial affairs. Some of the things that were mentioned, an explanation of what percentage rent in your lease means and how that's going to impact on you going forward. Everything from that to variable rates of interest and how they're calculated in loan documents. And don't forget the amazing resources that Prince George's County provides for you. For example, to enable you to learn about and connect with professionals, not just lawyers, accountants, contractors, consultants, specialists in any area that you might not have the knowledge and the information, the skill set to be able to help yourself in. And this is so important, before you commit to entering into a relationship with those people, utilizing references, reviews, recommendations, and especially referrals. Nothing beats a word of mouth connection to a professional that you're going to rely on. You want to know what kind of track record that person has, and to shore up your boundaries in those ways to protect you against the unknown and to protect you against missteps that probably could have been caught. There's nothing like that. Here's a secret for you when it comes to lawyers. The Court of Appeals, the Maryland Court of Appeals, if you go to their website, they have a record for the public of disciplinary actions against lawyers. Go there, check it out before you enter into a relationship. It's there for your benefit. And I really wonder how many folks in the general public really know that little bit of information that can make a huge difference. Why is the investigation worth it? You want people who will perform quality work for you and will therefore give you the greatest hedge against failure in specialized areas, the areas that I just mentioned. But suppose you do all of that and it doesn't work out. Suppose our craft maker, to keep it hypothetical, has to file bankruptcy for legitimate reasons. Well, what happens then? And we're going to look at this. There may be some folks on the landlord side, and you're going to get information here too, but we're going to look at it from the side of the tenant filing bankruptcy, because that's the proactive party in this instance. That's the entity that takes the step of bringing it all into the bankruptcy court. And so let's look at it from that perspective, and you'll get the landlord's side of the equation too, from learning about how it operates for the tenant, the debtor in bankruptcy. So what's the overall goal of a bankruptcy proceeding? To provide a fresh start to the honest debtor and equality of distribution among creditors of that debtor in the same class. Now, there's a lot to unpack there. I don't think I'm going to go into the weeds in trying to unpack it, but I think that's a very good, well-rounded statement of what the goal of bankruptcy is. It's a federal system, not a state system. When you file bankruptcy, you are in federal court, which is the reason why so much other law gets turned upside down when you're in bankruptcy. And that absolutely includes contract law, real estate law, commercial law, sometimes domestic law, sometimes tax law. And that all comes within the heading or the ambit of the supremacy clause of our wonderful Constitution that allows Congress to do this through the bankruptcy code. All right, quickly, Chapter 7 bankruptcy. The goal is to investigate and liquidate the debtor's non-exempt assets, determine whether there is non-disclosure by the debtor or fraud even, pay creditors, and for the debtor to receive a discharge, which is bankruptcy's holy grail of the fresh start. Chapter 11, I'm sure you've heard of that too. That's the reorganization. That's the general reorganization proceeding. And that is the goal of it, in a word. A breathing spell to permit readjustments of assets and liabilities, to enable a debtor to get through the hard times without the pressure that would exist without the bankruptcy case, and to do it in a way with the goal of becoming financially healthier. Chapter 13, you may have heard of that too. That's sort of a hybrid of both of those for the consumer debtor. I always kind of thought of it as the I want to save my house chapter of the bankruptcy code, and that's mainly what it's used for. If you are the creditor or the counter contracting party, and your debtor or counterparty files bankruptcy, then you will be required, usually, to be patient, as the bankruptcy code is written with the hope of success for the debtor. And in a word, that's why it can seem so frustrating to lay people who cannot enforce their debt, who have to wait, who have to allow the process to unfold. There's a reason for that. It goes back for many, many decades, over 100 years. Without getting into all of that, the point is to allow a business to try and survive and to come back and be financially vibrant and contributing to the overall common welfare. Important points: the automatic stay and the estate. The automatic stay is the core of bankruptcy, but it goes hand in hand with the bankruptcy estate. And they are creatures of statutory law, meaning that they are written down in the bankruptcy code, put there by Congress to be amended from time to time as the years go by. Courts must have jurisdiction to legitimately decide a case, any case, all right? That means power over the case, power over the subject matter. And especially in bankruptcy court, it means that these courts exercise jurisdiction over the debtor who files, but also over the debtor's property. And that's what we mean by property of the estate. And when a case is filed, all of the debtor's property interests, wherever they are, wherever they're located, become a part of that bankruptcy estate. The automatic stay is what we call, what we learned in law school to be a great legal fiction that stops all creditor action against the debtor and property of the estate. Why do I say legal fiction? Because nothing really happens except the filing of the bankruptcy petition in the bankruptcy court. But when that happens, it has a huge impact on any creditor action against the debtor. It is as if a giant wall goes up between the debtor and the debtor's creditors to protect the debtor going forward as the case moves on, subject to the discretion of the bankruptcy judge that's sitting on the case. Together, the automatic stay and property estate are the heart and soul in bankruptcy. And then the multiple varied and complex rules of the bankruptcy code take over to administer the case for the purposes I mentioned above. I'll just say this, and then I'll get to contracts and leases. Bankruptcy's basic bargain is the trade between the debtor and its creditors, consisting of the debtor's duty to be completely honest as to his or her assets and liabilities as written down on the schedules under oath in order for them to receive the discharge that will wipe away all of their pre-existing bankruptcy debt, except where it doesn't. And that's another complicated, in the weeds sort of issue. But that's the general way of describing it. So let's get back to our craft maker. She has her lease with her landlord with 3 years left on it. What happens if all else fails? She's gone to Prince George's County Economic Development Corp. They haven't been able to aid her with a resource that can get her to a solution. She's talked to her accountant, she's talked to her lawyer, she's tried to negotiate with her creditors. All else fails, and she needs to file bankruptcy with unpaid rent on the lease. All right, the bankruptcy code has extensive provisions dealing with unexpired contracts and leases. What does unexpired mean? It means they're still in effect. It means the contractual term, either the agreement that deals with services or products or deliveries, et cetera, or the lease, which is the basic relationship between the tenant and the landlord, has not yet come to an end. It has not terminated. The bankruptcy code gives the debtor trustee the discretion and time to choose which agreements to keep, assume, as we say, and which to jettison, reject, as we say. How much time? It varies depending upon the type of bankruptcy and type of contract. In the case of leases, the landlord lobby has done an impressive job towards shaping the bankruptcy code to reflect their client's best interest, which means landlords have a lot of power when the bankruptcy case is filed. But then there's always pushback from the basic goal of the bankruptcy code, which is, as I said, successful reorganizations. In fact, this just off the presses, in the midst of the pandemic, Congress has granted small businesses some relief by extending the deadlines for dealing with making a decision with respect to assumption and rejection of commercial leases. And I think we'd all agree that's probably a good thing, all things considered, right? If our craft maker wants to keep its business lease, then she must continue to honor it, including especially rent payments. The craft maker can defer lease obligations when the bankruptcy case is filed, including the payment of rent for 60 days and sometimes 120 days pursuant to these new amendments to the bankruptcy code. But that does not make the obligation go away. You're going to have to pay the piper sooner or later in order to have a successful case. It must be paid and keep the lease if that's what your intention is. It must be paid and paid as an administrative claim, meaning 100% in full. And that payment in full will include past due or rent arrears that existed before the bankruptcy filing. And ultimately, the debtor will have at least 120 days and possibly more to make the final decision on whether to assume or reject a lease. If the lease is assumed, it's as if the lease never was disturbed by the bankruptcy. That's the bottom line to that. If it's rejected, then the liability for damages is converted into a general unsecured claim as if it arose the day before the bankruptcy case was filed and need only be paid what other similar creditors are paid in that particular case, and the liability is removed from the business for all time. You don't have to worry about it. To hook up with what Vernon mentioned about assignment, you can do that in bankruptcy too. We call it assumption and assignment. But if you do it, there's going to be a responsibility, just as with assignment, to treat the lease as if it never went away and as if the bankruptcy case had no impact on it. Depending upon the particular case, and this is really important, all of these issues might be much more nuanced and complex, but that is the general breakdown when it comes to leases and other unexpired contracts. So our hypothetical craft store would have a fair amount of time to turn things around and what might be a desirable ending in her case. And I know I've run over time a little bit, so I'll just say real quick, the point of it is to file a plan that can be confirmed. If the decision is made to assume the lease, then you're going to have to continue to pay it under the plan, and the plan's going to have to honor that. If the decision is made to reject the lease, let's go back to the beginning. What problem caused this? The location was no longer as quality as it was when the lease was entered into. In real estate, it's always location, location, location. Rejection of the lease can give that debtor the opportunity to move somewhere else, to start business over in a new location. There's probably a lot of free space now in the midst of the pandemic, and use bankruptcy and that. So it gives you options, gives you choices, and it's nothing to be ashamed of if it has to be done. But I think the goal of everyone here would be to exercise your discretion in favor of your business, your judgment, to have professionals that guide you as best as possible, so that barring uncontrollable circumstances, you're able to avoid this as a result. But just know that experts are here to help you if it becomes a reasonable option for you. And thanks for the opportunity to speak to you today.
Wow, this has been an excellent panel, my gosh. So the lesson learned on the front end is obviously you want to know what kind of contracts you're entering into. You want to get that letter of intent. You want to maybe consult an attorney to have them go over the lease and make sure you're signing something that's favorable to the tenant versus just to the landlord. You want to understand if you're trying to start a new business and you're entering into a new lease agreement and you have to do some work and there may be permits involved. How do you make sure that you get into a contract that doesn't actually start you paying rent until you get your permits in place, etc. Just so much good advice here. I can't even begin to just thank you all so very much for the wonderful bits of advice. I'd like to hear everybody put in the chat one takeaway that you've taken away from this. Please let us know something that you learned today that you did not know before today's session. And again, we have everybody here. I don't know what everybody's time is. We tried to ask questions earlier on, but if people still have questions, I'm sure we can still accommodate one or two in the chat. Again, we are just really thankful to Lord Charlie Brewer. We just have, we're grateful for this partnership and all the programs and all the information you've been bringing to small businesses. And the fact that you've been small business owners yourself and kind of have lived through this, you're speaking from the voice of experience, which really is really helpful, right? Because you have the lessons learned, and that's so very important also. Are you keeping hold of these legal contracts? What are you doing with them? Are you monitoring them? Are you abiding by those agreements? It's all, extremely important to small business owners to kind of just bear in mind that you are signing something that is legally obligating you to commit to something, right? Whether that's paying something, working with a vendor, whatever that may be. So any final thoughts from the panelists, any last takeaways or any last, again, let's see, what is everybody, come on everybody, give us some feedback. Let's get something going in the chat. Tell us one thing that you learned today that you're taking away from this, if you would. And then just know we'll continue to work with our partnership with this wonderful law firm whose founders and kind of some of their principal players are based in Prince George's County and know Prince George's County well, as do many of their partners and lawyers within the team. So they have a wealth of expertise, everything from company formation, as we've talked about, to employment law, to understanding other elements of running a small business, whether it's contracts, etc. So any final words from the group here? I think I'd love to hear from the speakers. Any one last final thought from everybody?
If I can ask Sharon or Robert or Vernon, we went over a lease, but how fundamental were a lot of the provisions? Obviously, Vernon went through a very detailed look at the lease, but how translatable is that to other types of contracts? If people have, I know any other type of contracts, we have real estate and bankruptcy attorneys here, but how does the lease translate to other types of contracts?
Well, I think one of the things we were trying to, make clear as we chose, a lease, as a form of contract, is that as Sharon went through the various elements of contracts, that's going to be the case with every type of contract. But the principal thing is contracts contain obligations and rights of the respective parties to the agreement. And a good contract will also spell out, rather than leaving unaddressed, what the remedies of the non-defaulting party is if the other party to the contract defaults. That way, each party can understand what their respective rights and responsibilities are. The defaulting party can understand what the scope of its liability is. And to the extent the contract does not address specifically default and remedies, then the parties are going to be left with the common law, I guess, conclusion in terms of, how the rights and remedies of those parties are going to be determined by the law. And the parties will not have had an opportunity to, let's say, tailor, what those rights and remedies, are. So I would say a big takeaway is there are obligations and rights set forth in the agreement, and it's extremely important for both sides to understand them. And it's extremely important for both sides to perform their respective rights and obligations. And that's in any contract.
Great. All right, and I see one final question here, and then we'll wrap up. What does the panel think of Legal Shield or other plans such as ARAG?
I'm not quite sure what those are. My assumption is that you pay a certain amount for certain online legal services. Is that correct?
I'm Googling it right now.
Correct. Okay.
Yes, correct.
We're not going to be able to learn enough from Google to really opine on it. If it's some, legal service provider, I'm not familiar with it. So I really wouldn't want to say one way or the other. But I'll just say there's nothing like having a personal relationship with a trusted advisor that you can count on, period. There's no substitute for that.
Right.
Yeah, and I think, I don't, again, not knowing exactly how those entities operate, lawyers are licensed to practice in jurisdictions. If you're getting someone who's licensed in Wisconsin who's trying to answer a question for you in Maryland, that might not be the lawyer you want to take advice from. So I think, I don't know exactly how those entities are structured, but not every lawyer can do everything everywhere, if you get what I mean. We're licensed, I'm licensed in Maryland and DC, I think, so those are where my knowledge base is located, and those are where I'm supposed to be practicing. So I think I would be careful to see what kind of lawyers are responding, to whatever questions you have, because you need to make sure that they really do know the law of the jurisdiction that you're in.
And
can practice there, Can practice there,
yeah.
So businesses are at different stages, and so people may need to work with legal resources at the library, work with legal resources. This is why we're doing this kind of programming, because we're trying to bring legal expertise to the business community and these Q&A periods so that you can ask the experts, because an hourly consult with an attorney may be a fee. And so if somebody's starting out, what are your suggestions on that? Do you have any suggestions from the group on if somebody is starting out a business and maybe doesn't have a ton of money? Any recommendations for those, or how to utilize an attorney most efficiently, perhaps, in that situation?
Yeah, I think most lawyers will spend some investment time, with a potential client, particularly law firms that have kind of a business arm to it, to see if they can assist. Or lawyers are always good referral sources for other lawyers. So even though, the fees may be too high at one firm, a lawyer may know a sole practitioner at another firm that has an expertise in that area that can very well help that person at a much lower rate. I think it's always important to understand, how lawyers, when you're a small business, how you engage a lawyer. What's the engagement letter say? What's the hourly rate? What's the other type of potential alternative fee arrangements that you may be able to enter into for a particular matter? So, it's also knowledgeable to talk to other lawyers who can actually share with you kind of what you're going to, what you should expect or can expect when engaging a lawyer or an accountant or any other professional in that regard. So.
Right. We always encourage people to have your team, have your lawyer, have your accountant, have your core team to help the business as they're growing. But obviously, we're realizing that we're working with companies at all different stages here. And so thank you for that good insight. Very helpful.
Thank you.
Yeah.
Okay.
I think we may have gone through all the questions at this point in time, and I just want to thank everybody. Again, Scott will be sending out the slide deck, and we'll also have the slide deck and the recorded session to share with you all. I want to just thank Mr. Gordon, Mr. Lynch, Ms. Craig for all their assistance and guidance, information sharing. It was fabulous. Well done. Thank you all for participating and for being our partners. And their contact information is on the last slide in the slide deck that you will be getting, and that's also up on the screen. So thank you everybody for participating in today's program, Innovation Station and Lurch Early Brewer. Thank you.